rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We are here. Good morning. We're here on our case number 1 SA190067. State of Arizona versus Honorable Mahoney and the Ragsdales are the real parties in interest. As you all know, we have each side's allotted 20 minutes for your argument. The petitioner may use any amount of time you'd like to use in rebuttal. If you do decide to reserve time for rebuttal, though, you're in charge of keeping track of it by yourself. The clock on the podium will reflect your total amount remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if when you approach the podium, you'd give us the name, your name, and the name of your client or clients for our recording. We have closely reviewed your filings and the appendices, the case authorities, rule, the statute, and we've also discussed the case in our conference. So with that, you may proceed.
Good morning. May it please the Court, I'm Brock Heathcott, Assistant Attorney General, representing the state of Arizona, and I would like to reserve 5 minutes. I'll keep an eye on it for rebuttal. The trial court here treated plaintiff's motion as a Rule 26 procedural motion, but then applied a direct evidentiary standard to that procedural rule that was even more stringent than the evidentiary standard under Orm School.
Do you think it matters?
I do think it matters.
Why is that?
Because Rule 26 is procedural in nature, and its purpose is to advise plaintiff, to disclose to plaintiff a theory of potential liability based on facts that are believed to be true in the case. Rule 26b-5 does not require a defendant, and it can't require a defendant to provide all the evidence necessary to prove the non-party at fault, because the non-party at fault must be filed early in discovery.
Well, but you're not contending you're ever going to find out who these ATV drivers are you?
No.
So does it matter then? I mean, isn't the relevant issue whether you're going to need to at some point?
Well, we can't find the ATV riders. Nobody's going to be able to find the ATV riders. But cases like McKillop and Rosner make it clear that you don't have to actually find the people.
And that's your argument.
And that is
and not that you don't need to say it earlier rather than later.
Well, I think the Orm School standard applies under motions for summary judgment. And in this case, the plaintiff titled his motion as a motion for summary judgment, but didn't put any evidentiary standard in the motion, and the court didn't treat it as a Rule 56 motion. But the manner in which the process should work is the notice of non-party is procedural, identify facts that could support liability, and then subsequent discovery could lead to the plaintiff filing a motion for summary judgment, and Rule 56 is the vehicle by which that would be judged, using an Orm School standard. In this case, the defendants easily met the Orm School standard. Circumstantial evidence is as persuasive as direct evidence under Arizona law and is given equal weight. For some reason, the trial court had an unreasonable skepticism of circumstantial evidence in this case, and created some sort of new standard that requires direct evidence to prove a non-party at fault.
In other words, to prove the identity of the non-party at fault, or that a non-party at fault did something fault-worthy?
The latter. I believe the court applied a direct evidence standard to the holdings in Bowen and Sendejas that doesn't actually exist there.
Is it? We'll ask your colleagues as well. But is it undisputed that the that the right-of-way fence could not have come open but for a human being's acting on it?
There has been nothing disclosed by any party suggesting that it could have happened any other way. And the factual circumstances of this particular kind of gate, which is a spineless gate, it's just wires on a hook. Yes.
We're just looking at that.
It is a spineless gate, and you can see it in the photographs.
Well, very well. Yeah, we.
Do we know how long the gate had been open? I mean, is there any evidence?
There is no evidence how long the gate had been open.
Not even as an outside, not
There's none.
There's
No, I'm sorry.
some testimony by someone who said that a gate was closed, but which gate was she referring to?
I don't know.
Yeah, I thought there was one of the ranchers or their spouses had said they drove and checked the gates the day before.
Yeah, I'm sorry. Yes, she was talking about the pasture gate, which is a different gate. So in this case, there are 3 gates. There's a corral gate, which was intentionally left open so the horses could get out in the pasture. And then there's a pasture gate that shouldn't have been open but was open and the horses got out. And then there's the right-of-way gate, which is the one that we're here talking about because that's the only one that implicates state liability. The plaintiff's contention is that that right-of-way gate should not have been there or should have been closed.
And when you say a spineless gate, do you mean
It's just wires.
where so each of the wires was hooked to a loop? That doesn't make sense.
Yeah, there's a.
I mean,
So
the picture you have in Exhibit 5, I'm sorry, not you have, the picture that's in Exhibit 5.
About
I think
246.
that looks like it's wadded up in a ball.
Yes.
I mean, in the middle, lying in the middle of the tracks there, to the right of the what appears to be ATV tracks, and you can see the keep gate closed sign. But other than that, I mean, you don't see anything of. So yeah, how would someone attach that to the other side where the?
So there are multiple ways that could one of these gates.
This appears very different from the ranches that I'm used to working on. So.
Right. There are
We're
multiple
deferring to
ways.
Judge Brown for that, so you got to talk to him about what the fence looked like.
There are multiple ways that these Texas gates can be created. This one is really primitive. If you just have a wire fence, you can cut each of the wires, and then you can wrap them around a post. And then you can loop that post using a separate piece of wire to another post to hold it in place. Then when you unloop it, it lays on the ground like this because there's no spine to any of the
And
wires.
there's not really another side.
And there,
It's not really a gate in that traditional open and shut fashion. It's just you've cut a hole in the fence and you can lay it down or
correct.
have it.
And then,
Okay.
this one seems to have 4 strands of maybe barbed wire. Do you have to loop each of the 4 over the
Well,
post?
one way you can do it is that you get a piece of wood, a wood post,
Which seems to be
stay.
precedent.
a
Yeah.
stake, and you
Yeah, right,
wrap
stake.
each of the loose ends around that stake, and then that stake can be a post, and
And how do you fix the stake?
you loop it using another piece of wire around an existing post that's on the fence.
Okay, maybe so they were hooked on.
But it doesn't appear there's to be a stake. We ranchers call those stays, S-D-A-Y, actually. So,
Okay.
But there doesn't appear to be any wood portion to this gate, correct?
It does look that way. I'm looking at image. Is it 248, the one that has the keep gate closed sign on it. You can't tell there. It doesn't look like there's a stake of any kind, which would mean that the wires would have to be affixed to each other using another strand of wire.
Okay.
Or look at-
Okay. So just to go explore this. So what evidence there, or how reliable is the evidence, or is it just pure speculation that this was ATV drivers as opposed to a gentleman who needed to, was driving along and needed to, use the restroom and needed to and drop and wanted to go a little further than the bar ditch and wanted to go farther. So, how do we know? Isn't there a lot of speculation tied to being ATV drivers?
I don't think there's a lot, because the only evidence of anyone being there is the ATV tracks. So if we were going to present evidence of some person that opened this gate, it's clearly been opened far enough that it tracks that people can drive through it. If someone was just walking through to relieve himself, he might just drop it right there, wide enough for himself to get through. Or if somehow the horses had kicked it open, which I'm not sure that would be possible, they wouldn't have opened it the entire way so that they could run through it.
So here's the thing, though. You don't really care whether it was an ATV driver, or some hunter, or some person just wanting to take a walk.
Correct.
Your theory is it was another human being.
Correct. Plaintiff's
That was
theory.
the but-for cause of this accident.
Correct. Plaintiff's theory relies on the gate being open. And what we're saying is that we didn't open the gate. In fact, we were out there. You asked earlier if there was a time at which the gate was shut. We were out there, I believe, 2.5 months before this accident and checking the fence line. And so our people will testify that at that 2.5 months prior to this accident, there was no gate there.
Now, I'm trying to think of, contrary to what I just said, how it could be that you would care who it was who opened the gate. If the task of the jury is to allocate fault, maybe the facts surrounding how the gate was opened would bear on that third party's fault. Was there an emergency? Was the person had been rendered physically unable to close the gate? I mean, those facts would bear on allocation of fault if you knew them, right?
They could. There are other facts that might bear on allocation of fault. For example, it was determined during discovery that the plaintiff's family owned ATVs and that the co-defendant's family owned ATVs. We don't know how many people owned ATVs out in that location. We know that this particular spot is where SR-77 cuts across a dirt trail called Leadville Street that leads way out east towards Rattlesnake Canyon, and that it's probably a very popular ATV location and Jeep location. The people living there in the community, likely a lot of them had ATVs.
Probably only one person here knows where Dudleyville is, but I do. Yeah.
So the plaintiffs seem to believe, based on their brief, that all the standards for notice of non-party at fault that we've talked about in this case concern naming of the non-party, and they place a strange focus on words like might be at fault or could be at fault, as though the inability to identify that specific person as being at fault is the defining feature of these cases, but it's not. It's clear from Rosner and McKillop that an unknown, unidentifiable non-party can be named if the evidence assumes their existence. In McKillop, the paper on the floor assumes the existence of someone who dropped the paper on the floor. And the same is true here. The open gate assumes the existence of a person who opened the gate.
There are cases, though, this court has issued cases that say that the purpose of the statute and the rule is to allow the plaintiff to hail into court folks who might be at fault. Does that bear on whether we should enforce the rule, which says that the defendant needs to identify the non-party?
Well, I think if that is if I may be so bold, Your Honor, if that is the standard of the law in Arizona, then that needs to be clarified, because the purpose of the notice of non-party fault is not really to allow the plaintiff to bring someone into court. The purpose of the non-party fault is to allow the defendant to only be assigned the fault for which they are liable. That's the substantive right that exists in the notice. I will. If there are no further questions, I'll reserve the remainder of my time.
Thanks.
Elliot Wolf on behalf of the Ragsdales. If I may, I'll address the two issues that you raised, Your Honor. The state's first argument at pages 9 and 10 of their petition, which they repeat today, which is wrong as a matter of law, is that we don't have to satisfy the Rule 26b-5 requirements of identity, location, and facts to support it, because that's a procedural rule and it cannot limit the statutory right under 122506 to allocate fault to non-parties. But that entire argument ignores Sendejas. And by the way, remarkably so, they didn't talk about Sendejas in their motion, in the response to the plaintiff's motion. They didn't talk about it in the motion for reconsideration, despite the fact that the trial court specifically cited it and discussed it, and they didn't talk about Sendejas in their petition.
Well, how does that case bear on this case?
Because in Sendejas, the court specifically said that we did not rule in Rosner that you do not have to follow the requirements, meet the requirements of Rule 26b-5, and specifically said that. And the trial court said, yeah, I'm not allowed to, you're not allowed to ignore those requirements. And so the state's response is, well, to you and the trial court was, well, read Rosner. Where we can give notice of an unknown, unidentified, and unlocated non-party. But as I'm sure you know, because you've read the cases, that in Rosner and the other cases that they cited for that proposition, they were allowed to identify, to not identify by name the non-party at fault, because the non-party at fault was specifically known and seen to have committed the alleged negligent act that injured the plaintiff. And in Rosner, the court went out of its way to say, as repeated in Sendejas, that the defendant had conducted an investigation at great length to identify and locate the unknown, the names and locations of the non-parties. They did neither of this in this case, and the trial court specifically made a point of saying at oral argument, she asked the state, did you make any attempt to find who these alleged ATV riders were? And they said, absolutely.
What could the state have done?
Well, the state, you should know that, for example, there is a landowner, and it's not defendants Phillips or Hellers, the horse owner or the pasture owner, who owns the land right adjacent to the fence. So if you open the...
Oh, so there's another ownership.
Yes, Texas Gate, that strip is owned by somebody else. Never identified, never asked, by the way, did you open the gate? Is that your ATV? Do you have an ATV? None of that. What the state says, and by the way, that gate, the fence is a barbed wire gate.
Okay.
Okay? Fence is a barbed wire gate. I'm sorry, the fence is a barbed wire fence. And the gate, the Texas Gate, is simply also barbed wire with a loop on the end of the top of the barbed wire that slips over the tip of a post. And so the state, we have an expert who says that was done, by the way, to state specs. State says it's not our gate. We didn't put it there. We never saw it. We didn't know it was there.
Okay.
Didn't maintain it.
Is there any dispute that a human being opened the right-of-way gate?
Well, we don't know, Your Honor, because this can be opened by a child. I mean, it's just...
A child is a human being.
Right. Well, but
is there any dispute that a human being opened the right-of-way gate?
Well, we don't know, because it's so easily opened, and what I was starting to say was, State didn't maintain it, State didn't know it was there, State said if we saw it, we would have taken it out, they didn't, and they don't know if it was maintained. We don't know the condition it was in,
Okay,
or how long it was there.
But, all those are arguments for the jury. What I'm interested in knowing is whether there's any reason to think that the gate opened either by itself or by a horse.
Well, it could have been either, because what I'm saying to you is we don't know who put it in, or they don't know who put it in. It's easily opened. It's just a loop of barbed wire. We don't know how
Holding
long
your
it was
hand
there.
back. You're not suggesting the loop is just 1.5 inches wide, are you?
Yeah, that's all it is. It's just a little loop at the end of the barbed wire that fits.
Is there any evidence of what the gate looked like being as it was shut? We don't know that. All we have before us is a pile of wire on in the middle of the dirt.
Yes, that's right, because when you slip off, or that thing slips off, the loop slips off, the thing collapses. It's just barbed wire. And so how long was it there? Nobody maintained it. We don't know what condition it was in. We don't know if a storm opened it. We don't know.
Storm?
We don't know. We don't
How
know.
would a storm open it?
I don't know. Wind?
Well, see, that's
But isn't that just as isn't your theory just as just as speculative as the State's theory?
Well, the answer,
Perhaps.
I think the answer to that, Judge, is if their theory, and it's just a theory, is speculative, it doesn't meet the requirements of the non-party at fault designation.
But let me follow up to Judge Johnson's questions. I'm talking about, is it speculative that anyone other than a human opened the gate?
Well, we don't know. We don't know one way or the other. I have to say that. But they didn't say any human
But
as a non-party at fault. They
Well, how does
said
that matter,
ATV
though?
riders.
How does that matter? If the theory is that a human being had to open the gate, that some other human being not named as a defendant is a but-for cause of the accident, then how does it matter whether that person is an ATV driver or somebody else?
Well, I guess number one, because they didn't. They made a specific designation of an ATV.
Well, I know, but I'm
Rider.
asking, just for our purposes in ruling on the case, how does it matter?
Well, they have the obligation under 26.B5 to identify and locate any human being in the world. What they can say is, we didn't put it in, somebody else did, and we're not at fault for that. But we don't have any notice where we can bring anybody into the case or find. We don't have a duty to embark on that investigation, as you know from the case law. That was their responsibility, and they didn't do it.
But the theory of plaintiff's case against the state is not that the state opened the gate, right?
Yes.
Okay.
Well, we don't know, because counsel said something to you, and he left something important out. He said that the Hellers had an ATV. Phillips probably had an ATV. We don't know if the landowner there had an ATV. But what he left out was the state has an ATV, and the state uses its ATV to inspect its fence line. Did they find it and go through it? We don't know that either.
But I read the complaint, and the complaint alleges that the state negligently installed and maintained the fence, the gate, not that it opened the gate.
Yeah, we don't know who opened the gate or what opened the gate, nor do they. Was it opened and closed by ATV riders weeks before this ever happened, and then somebody else came along and opened it? We don't know that. Was it opened by landowner or somebody else, and the ATV riders came along and saw it was open and went through it? Or someone took a potty break because they saw it? We don't know any of that. And the defendant has admitted, unlike in Rosner, where there was an exception made where they couldn't identify, by name or location, the assailants, they've admitted that they made absolutely no effort. They just named, non-parties at fault, ATV riders. with no effort to find out who they were, no inquiry. So what they say, Your Honor, and this is where the speculation really, I think, comes in. What they say is, well, okay, well, there's a police report, and the police officer, according to them at page 8, this is their words, at page 8 of their petition, the police officer surmised, that's their word, that ATV riders, because he saw ATV tracks, ATV riders must have opened the gate. So I urge you to look at the definition of surmise, which...
Well, but we have the report. We don't need to rely on the state's characterization of it. The report says that the DPS investigator found ATV tracks through the gate.
Right.
Which I take to mean on both sides.
And I do too. But when were they put there?
Well,
Yeah, we don't know that. And that doesn't tell you, because there are tracks there, that an ATV rider opened the gate or failed to close it. It just tells you that they went through. And surmise means specifically guess, speculate, theorize, or suppose something is true without having evidence to prove it. So, and by the way, I should say that the police officer's opinion that an ATV rider opened the gate within a hearsay document is hearsay within hearsay. The document itself may have a hearsay exception as a public record, but his opinion does not. He wasn't deposed. He was never deposed. They provided no affidavit to controvert the motion. It's like a police officer going to a scene and seeing skid marks on the roadway and not knowing if they're even from this particular incident and saying, well, I think this shows that the defendant was at fault. And under Rule 702, there's no scientific method or reliable application. It's just an opinion within a hearsay document, a hearsay opinion within a hearsay document.
are you saying that the DPS report should not have been relied on by the Superior Court in ruling?
Well, she did rely on that and found that
Did you move
there
to
weren't
strike it?
sufficient facts. That was part of the hearing, and as you mentioned it now, I probably should have gotten a transcript of that, but that was specifically discussed during the argument on that. So,
Counsel, how is this case different from the McKillop case and
Oh.
Smitty's case, where there was obviously no eyewitness or specific identification of whoever dropped the object on the floor that led to somebody having to slip and fall.
Right.
I understand that the court there did not evaluate the merits of the notice of non-party at fault, but the court did affirm the allocation of fault by the jury.
Extremely different, and factually and legally. And as the trial court pointed out, McKillop's didn't even have this issue before the court. The only issue raised in the McKillop's case was a purely legal issue. And the question was, did Smitty's failure to have a mode of operation that checked for stuff on the floor periodically, if we prove that, are they allowed to make a non-party at fault claim? That's the only issue. That was a purely legal issue, because there was absolutely
But what was the answer to that question? The answer was yes.
Yeah, you can do that, but what the court didn't...
But with that, just to anybody? Like anybody in the world left that?
No, because what the court didn't get to, because it didn't have to, it was just saying, yeah, you can make a non-party at fault claim, but it never got to whether or not that claim, factually or legally, would satisfy either the statute or Rule 26B-5. Would it have satisfied identifying the person? So, for example, I'll give you an example, and the court actually, I believe, said this in her ruling. She said, well, for example, there is no investigation as to who may have dropped the paper on the floor. What if it was a Smitty's employee?
But here, there's no dispute the plaintiffs are not alleging it was the state employee who left the gate open.
Well, we don't know who left.
But
the
you're
gate
not alleging it.
Well,
That's not the theory of your case.
We didn't allege it in the complaint, but as I said during discovery, we discovered, without them having disclosed it, that one of the things that they do when they inspect their fence line is they do it with an ATV. So can I prove that they did it? They'll deny that, of course. But can they prove that an ATV rider opened a gate? No, of course not. They don't know. Could have been a hiker. It could have been the trespassers.
Does it matter?
Yes, it matters. Because,
Why does it matter?
because they specifically are trying to have the jury allocate fault to an unknown, unidentified, unseen ATV rider. That's their claim.
But if they don't come up with enough evidence, then it's not, the jury's not going to apportion fault to an unknown ATV rider.
Well, I think what the court did is, they want to couch this as if this is a purely illegal issue of first impression. And if you read, and I know you read, the trial court's ruling, what the trial judge did is say, no, as a question of fact, you haven't satisfied the requirements of Rule 26B5. You're just speculating about this. You haven't identified for the plaintiff who it is so they could bring them into the case. You haven't done any investigation even to try and do that. And you're just saying ATV tracks where we don't know how long they were there, who put them there, if a gate was closed after them, that the jury should be able to allocate fault to that unknown, unseen, unidentified party. The state can certainly say, we're not at fault because we didn't put the gate in and we didn't open the gate. And if the jury finds that, the jury will obviously, I guess, find in favor of the defendants. So, which brings me, I guess, to the last thing that I should say about you accepting or not accepting the petition. We believe that the trial court's finding that a notice that just says unseen, unknown, unidentified, unlocated ATV riders, who we made no effort to find, fails to comply with Rule 26B5, and that ruling by the court, which is factual, not purely legal, is not clearly untenable, is not legally incorrect, and those are that's the definition of abuse of discretion. There was no abuse of discretion, and in terms of whether or not there's a plain, speedy, and adequate remedy, I guess I should say special actions, if decided quickly, are always speedier. But in this case, there's an adequate remedy by appeal, which may never have to be taken, because if their position is correct and they didn't do anything wrong, then they'll get a defense verdict and there'll be no appeal. This issue will be moot.
Do you have a trial date?
I do not believe we do. I think we have a hearing coming up to set a trial date.
Would, if the state, I'm just curious, the state, if the court had allowed the state's notice of non-party at fault to stand, the other two defendants would have benefited from that, right? Maybe? I mean, separate and apart from the issue about a hunter non-party, the allocation of fault would be one allocation of fault among all the defendants.
I guess I haven't thought that through, but I suspect that even if they didn't join, they probably would benefit. Because,
that's a better way of putting it, yeah.
Yeah, because the percentage of fault, at least, I don't know, collectible against the state who made the non-party at fault notice, at least against the state, it would reduce the plaintiff's ability to collect the full amount if there was an allocation of fault to a non-party, because the state made the notice of fault. If it wasn't joined by the others and there's a verdict against them, not sure legally.
Yeah.
I'd have to think that through as to whether or not they benefit from that if they haven't made that motion in the amount that they owe.
It's an interesting issue in that the causation that requires each of the links to be filled to have the rancher be liable. So, yeah.
Yes.
Okay.
Okay.
Thank you.
Thank you.
The McKillop verdict is a perfect example of what could happen here. Had the McKillop jury been prohibited by the judge from assigning fault to the unidentified paper dropper, then Smitty's would have been assigned 100% of the fault, even though the jury did not feel that Smitty's was 100% at fault. They would have had to pay the entire verdict, including that portion of the verdict for which they were not at fault.
Of course, they could have appealed.
And they could have appealed. They did appeal. No, plaintiff appealed.
Yeah.
Yes. So I mean that's the nature of our problem here, is that the jury is not being entitled to assign fault to everybody who could potentially be at fault. And in this case, the people who left the gate open, the jury could believe very easily that they were at fault, even at the same time feeling that the state should have discovered the gate being open.
Has the discovery deadline passed?
Yes, yes, Your Honor.
Has the disclosure deadline passed?
Yes. In fact, all motions have been resolved at this point.
Is there any expert testimony about how one may open this gate?
The only expert testimony is from ranchers, expert ranchers, who say that this particular type of gate is one that is very commonly used by ranchers because it keeps animals in.
Are you sure the pasture gate or this gate?
This gate, the Texas gate, the loop gate, they like it because people can open it. It's easy to make. It's inexpensive. It keeps animals in. And there's a problem with pasture land, as with state right-of-way, of people cutting through fences. And if you've got a Texas gate here and a Texas gate over there, the hunters won't cut through the gate in a way that can't be put back together.
Cutting, you mean with a wire cutter?
Yes.
You mean cut through the fence?
Cut through the fence, yes.
Huh.
That's it.
Is-
Well, I'm going to have to assume that the photos provided do not do these gates justice, because I just don't see, I'm not seeing how, I'm really not comprehending how, because it looks to me like there's some wires there, and you would literally have to grab all four wires and attach all four wires to the opposite end, because there's no connection in the photo. In the photo, there's no post, there's no stick, there's no stay, if you will, that we can see. But we'll
Yes.
take at your word on that.
And you asked, what does it look like shut? And we have examples of Texas gates, photos that we can show in this case, but unfortunately, nobody shut it and took a picture of this specific gate. There's a cut in the fence some distance down that defendant Becky Heller went down and took a photograph of to show that there's another location where there was a cut in the fence.
Were there horse tracks in that area?
No, and in fact, the DPS officer testified that he went up and down the fence at the morning of the accident and confirmed that there were no cuts in the fence anywhere except this one particular gate location.
When you say the rancher testifies that it keeps animals in, is there any specific testimony about whether any animal would be able to open this type of gate?
Not in those exact words.
Is
But
there
you're saying-
something of an inference that you could point us to?
The inference is that the reason these type of gates are used by ranchers is because they can't be kicked down by horses. A stiff gate that's got a chain holding it together could theoretically be kicked open by a horse. These cannot be kicked down.
Wire.
What about a horse putting its nose under the wire loop and lifting it up?
Well, a horse would see it just as a fence, right?
Horses are pretty smart. Can be.
Well, we'll name that horse as a non-party at fault.
You do know, though, if there's no evidence in the record with some testimony saying this is, because I didn't hear a concession from Mr. Wolf that it was, that the only way this gate could be open was by a human being.
Right. He doesn't have anybody who will say otherwise.
Now, let me just, I want to ask Mr. Wolf, is that true? That there's no testimony to the effect that the gate could have been opened other than by a human?
I don't think anybody's interested.
Okay, thank you, sir.
Finally, the ATV issue, I think Mr. Wolf has misstated the evidence that ADOT does have ATVs that they use, but they did not implement them until after this accident. So according to the evidence in the case, it couldn't have been an ADOT ATV that made those tracks before the accident. I guess we have a disagreement about the evidence there.
And I'm sorry, but just to go back this picture again, the gate. You're telling us you don't know whether there was a piece of wood, a stake, or a stay that all 4 barbed wires attached to? Or alternatively, that each of the barbed wires somehow attached to were looped over the fence post?
The image on page 246 shows the post that the wires are supposed to attach to, and you can see a makeshift little piece of wood that's attached to that post. That's where the wire would be hung to hold the wires up.
The one that's at a diagonal?
That's only
Yes.
that's about an 18-inch stick you're looking at.
Yeah.
How would that keep animals in or out? I mean, to me, that's a method of wrapping, and that's another way to close a gate. That's instead of a loop, you grab that stick is sitting there, so that you grab that stick and you wrap it around the stay or the stake, and that holds the gate in place.
Uh-huh. Well, these are the only photographs we have, and there are some kinds that you have a post, and then you take the stick and you put it down inside the post.
Okay.
I don't think that's what this is. This looks like it's just a piece of wood that's strapped on by wire to the post. And
So you'd say you need to grab the wires and bring those over, carry those over to, stretch them over to the other side and somehow attach it to the other side.
yes, Your Honor, I'm assuming that there is some kind of vertical stake of some sort. You can see in the far left of that photograph, there is a stake in the fence. Those stake appear, those are connectors holding the wires together at that distance. So I'm assuming that there's going to be one of those as well that would hold the wires together separated. Unfortunately, we don't know for sure.
Okay, thank you.
My time is up. Thank you.
Thank you. Thank you to all the lawyers for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.